Hello. Hello.
Hello.
Sir, am I audible?
Yes, you're absolutely audible.
Sir, this is the final link, right?
Yes, sir. Yes, sir. Yes.
So can I put it on starting mode?
You can leave the meet or as you find it convenient. You can also leave the meeting now. Join at 9:55.
No, sir, actually I am placing this laptop in front of Massey, sir. So he will be able to continue.
Okay, then no worries, no worries. We can also do it that way. That's not an issue.
Okay, sir.
Okay, so you can put it on mute mode, and later on at around 10 we'll start. Okay, when
Sure,
other
sir.
participants join. Yeah.
Sure,
Thank you,
sure, sir.
Gyanji.
Thank you, sir.
Am I audible to you? सर मेरी आवाज अगर आप तक आ रही है तो नमस्कार सर। सर एक बार आप अपने आप को अगर अनम्यूट कर सकते हैं तो इफ यू कैन अनम्यूट योरसेल्फ। Sir, you're still not on the options in front of you. At the downside, there must be a few options. One of the options, the very first option is unmute. Right on your screen, at the bottom side of your screen, there must be an option. The very first option would be of unmute.
कर लिया मैंने तो म्यूट हो गया।
Yes, sir. You are now unmuted, sir. Yeah. Sir, namaskar, sir. Very good morning. Sir, this is Ayush on behalf of the Himachal Pradesh National Law University, sir. And we welcome you. We foremostly thank you for accepting our invitation, sir. Uh, I hope I'm clearly audible to you, sir.
I am able to hear you.
Yeah, thank you, sir. Thank you. Thank you. So, once again, sir, thank you so much for accepting our invitation. And we'll start in another 2 minutes, sir, uh, as is the scheduled time.
तो बोल रहा होगा इस
Once again, sir, a very warm good morning to all the participants. And our resource person, Professor I.P. Massey, sir, has joined with us. And we will be beginning with the session now. So, with the permission of sir, if I may be permitted to welcome you, sir, it'll just take 2 minutes. So, the point is, I don't think Massey, sir, requires any introduction, because we as students of law, all of us have read his books, have read his contribution to the subjects, and the distinction that he has achieved throughout the country in terms of academic accolades that he has achieved. Currently, sir is the Dean, Faculty of Law at National Law University, Jodhpur, and he is a distinguished professor of national repute. Prior to this position, serves the Professor of Law and Dean Faculty of Law at Himachal Pradesh University, which is the HPU Shimla. Sir has worked extensively with the Himachal Pradesh Human Rights Commission, and as we all know, his area of specialization is administrative law. Today, Sir has agreed to discuss the aspects of comparative constitutional law, and both the sessions that Sir would be taking, one session today and the other which is scheduled for 27th of July. In both the sessions, Sir would be discussing about comparative constitutional law. So with this introduction, Sir, I most humbly hand over the virtual dais to you, and we would love to hear from you, sir. Sir, please.
Am I audible to you now?
Yes, sir, you're absolutely audible. Yes, sir.
Thank you, Professor Singh. One thing I would like to know
Sir,
that how many participants you have in this program?
sir, the total number of participants who had registered was approximately 65. Okay, those who qualified. Okay, and we have been having sessions since Monday. Okay, the participants have been continuously advised to join the sessions prior to the resource persons joining. But sir, as you all know, we can only request the participants. We cannot force them to join. Yeah. So I'm really sorry. I seriously apologize for this, sir. I'm really sorry that the participants, the number of participants who should be there, they are not here. But yeah, that's it, sir. And sir, in terms of the academic qualifications, most of the participants are assistant professors. We have two associate professors who had registered and 6 to 7 scholars, research scholars. So that's the ratio in which it is there, sir.
Acha, the second thing I would like to know is whether all your participants are from the discipline of law or they are from different disciplines?
Yes, sir.
They
So
are
they
from?
are from the discipline of law. Discipline of law. We had only one registration, which was from the Department of Psychology. Okay. So there's only one register. Everybody else belongs to the legal fraternity, sir.
So, thank you, Professor Singh. If you are
Sir,
able
this is Ayush. Sir, this is Ayush. Chanchal, sir, because as you must be aware, sir, today we have the CLAT exam as well. So
Right,
Dr.
right.
Chanchal could not join. This is Ayush, sir. Ayush Raj. Yeah.
Ayush, Acha, you
Yes,
are
sir. Yes.
on the faculty of the National Law University,
Yes. Yes.
Himachal
Yes,
Pradesh.
sir.
Acha.
Yes. Yes.
So, welcome everybody. But before I begin, I would like to clarify one thing, that I am thankful to Ayush for such a good introduction, generous introduction, which we generally in India do. But I personally believe that the way he has tried to introduce me does not completely define me or describe me. So if you would like me to introduce myself to you first, then I would like to say that after putting such a long service in the universities in law, I have never considered myself anything more or less than a mere student of law. And I still consider myself to be the student of law. It is such a vast discipline, the growing discipline, that perhaps nobody can ever claim that I know everything about this discipline. And I have always thought that in a university level, there are no professors and there are no students. At this level, there are only scholars. So some are senior scholars. For example, we who have gathered here are senior scholars and others are junior scholars. We are all involved in the same pursuit, the pursuit of the study of law. Because I personally feel that unless we are all students, consider ourselves students, we cannot grow. So topic which I am going to share with you today is the comparative constitutional law. When I was looking into your paper of the seminar, I found that it is comparative public law and Hindu philosophy. So I will talk little about the Hindu philosophy in comparative law. But first I will talk about comparative law. I'm not able to hear. There is some noise somewhere. So this is actually not the best way what we are doing to sharing knowledge, but under the circumstances, perhaps we have to make the best out of it. Comparative constitutional law. We all agree that it is an era of universalist approach to everything. There was a time when we thought that perhaps best thing is to concentrate only within our own territory and to find solutions to our problem. But now in 21st century, in the age of globalization and liberalization of economy, all our research, all our teaching has become universalist as opposed to particularist approach. And this approach is very visible when we are thinking in terms of our constitution, constitutional law. So first, I will deal with you. If you have any question at any time, you can stop me and ask that question. Otherwise, when I have finished, then perhaps it will be possible for us to take questions. Because there are no students here, we are all on equal basis. So therefore, there is no hesitation, and we can learn from each other. So what is comparative constitutionalism, as we sometimes call? Is it a discipline under which we compare two constitutions? Is it a method of research that we compare two constitutions, what is there, what is in our constitution, other constitution? Or it is something more? Is it a separate discipline? So today, administrative law, the comparative constitution law has become a discipline. And in this particular discipline, we try to study the similarities and dissimilarities of various constitutions, deepest layers of various constitutions, which define the country and which defined its people. So not only we compare the two constitutions in terms of institutions, we try to understand what are the deepest layers of those particular constitutions. So comparative constitution is about understanding the deepest layers of constitutional system which provide identity and self-understanding to any political community. So our main stress is to understand those deepest layers. What are the deepest layers? These deepest layers are not easily changeable because they are the product of history for any country. They are the product of political movements. They are the product of socio-economic realities. They are the product of need and aspirations of the people. So our purpose is to understand those deepest layers of various constitutions. So therefore, it is not the study of similarity and dissimilarities. It is the study basically of the deepest layers of the constitutions. Therefore, what this discipline includes, the comparative constitution is a discipline which studies the similarities and dissimilarities of the deepest layers of various constitutions. Secondly, which define the constitution, which define the society, which define its people, which define the political system. And those deepest layers are such which are not easily changeable. So this is the basic purpose of the study of comparative constitutional law. Therefore, it is a separate discipline and not simply a method of research when we compare. So now, after understanding this, we understand that what are the deepest layers of various constitutions. For example, if we first take up the American Constitution, so deepest layers of the American Constitution which defined American society. And these deepest layers may change, of course, but not very easily. So what is the deepest layer of the American Constitution? Perhaps the first, democracy. Democracy, perhaps the first deepest layer. And we understand what democracy implies. The best definition that is given by the people, of the people, for the people. Because we have experimented with various systems of governance. And ultimately, we come to the conclusion that no system is perfect. But even then, the democratic system is one which may have all the weaknesses and strengths like any other system. But this is the best system so far tried in the world history. And therefore, democracy, where we elect our own government, our own representative. If a country is very small, we directly participate in the passing of the law. But if the country is big, then of course, in direct democracy, we elect our representative who represent us and pass law for us. Because no single person should have the authority to pass those laws by which the people are governed. Of the people, meaning thereby that our governments will be in power only so long as the people want. If the people want a change, then government must change. Of course, in some places you will see that government change after a defined period which is given in the constitution. But at some places, the government change whenever the people want to change their representatives. For example, in many states in United States, they have a provision in the constitution for call off their representatives. If certain number of people from a particular constituency, they make a petition, then your representative, you think that after the election he is not representing you properly, then that person can be called off. But after a particular time, the elections are held, you are absolutely free to call your representative. But 2 or 3 things I would like you to understand so far as our democracy is concerned and democracy is America is concerned. We have always a complaint that once we elect our representative for 5 years, then they completely forget their constituency, the people, and no matter constitutionally they represent the constituency, but they don't. They have their own agenda, which they pursue. The political party then has the own agenda to pursue. And the people become secondary. And this is the main problem so far as our democratic system is concerned. Because it's very difficult to say whether the elective representative in the parliaments really represent constituencies, really constitute the will of the people. So for that, 2 or 3 things are very necessary. For example, if you look to the American Constitution, then you will find first, the term of the congressman is very short. The term of the congressman is only 2 years. And here we have 5 years. So in 2 years, he is always conscious of the fact that one, I can be recalled if I do not represent the will of the people. And secondly, that in 2 years, I have to do something for my constituency because I have to come back for election. Here, 5 years is a very long period. Another very important thing is that in American democracy, a person cannot stand for election from a constituency in which he is not a voter. So he can only contest election from the constituency from which he is a voter. He has no option to change the constituency. But in India, a person can contest election from any constituency he likes. He can contest election from a particular constituency in which the people have not even seen him. And so, for a functioning democracy, because we say that our democracy is not functioning well. So one reason is that because our representatives are not responsible to us in the manner in which they should have been. Because if the people of a constituency are not satisfied with their representatives, then he will say, hell with you, I will fight election from the south this time, from any constituency. There you cannot fight election in any other constituency, except from the constituency in which you are a voter. So this is the most important thing. And then the provision for call off that makes the democracy perhaps more vibrant democracy than our democracy in the world. So this is the deepest layer that we can understand from the other constituency. Then the deepest layer of the American constituency is their Bill of Rights, the human rights, which are very dear to them. But perhaps you know that when American Constitution was drafted in 1787, American Constitution is a product of an agreement between 13 states. And in that particular agreement, perhaps you know that the whole country was divided into two, South and North. In South, there was slavery because there was those states were agricultural state, and therefore they wanted the labor to work and labor was not available. So therefore, labor was imported from Africa and they were treated as slaves. And without slaves, it was not possible for them to maintain their economy. So that was one group. The northern group was not basically agricultural, but it was industrial. So that situation was not there. So when the 13 colonies which were there in the beginning, when they met together to draft a constitution, then South people said that, look here, we do not want any equality, we do not want that there should not be any discrimination in this society. We want the slavery to stay. And the northern states said that no, we do not want. This will be a very dark patch on the history of the American institutions. And so therefore everybody wants that at least we should have a constitution at least for two purposes. One was to solve the problems of trade between the colonies and trade from outside, and also to save the country from external aggression. So they agreed, all right, constitution, democratic, but no fundamental rights. So when the constitution was drafted, there was no fundamental right in it. And 1791, and the Bill of Rights was added to the American Constitution. So a very special feature of the American Constitution, that constitutions are drafted keeping in view the basic interests of the vested interests. Another question of fundamental right was that when the Bill of Rights was introduced in the American Constitution, the question was whether it will apply to whole America. And now look at the interpretation of the Constitution. The Supreme Court said no. The human rights which you have included now in the Constitution are not applicable to states, because word is the Congress shall not pass any law. It means the states are free. So meaning thereby the interpretation of the Constitution depends on the social and economic actualities of a particular country. But later on, the stand of the Supreme Court changed and they said, no, it is applicable to everybody. Then another important feature of the American Constitution, the deepest layer, is the separation of power. Perhaps you know the history that why these people in 1607 left England and came to this deserted and barren place which was inhabited by certain tribes which we call Red Indians. There was nothing in this particular soil. So what forced those particular people, early settlers? So though you can understand the deepest layer, why they left England and they came to this deserted place to start a new life. Now understand, at that particular time in England, there was what we can call religious domination. The Christianity of the Catholic form was the state religion. And everybody was to accept that particular religion. Theocratic dictatorship was there in England. Any person who had any other faith or worshipped God in any other manner than the state decided was very brutally treated. People were burnt alive. Theocratic dictatorship was in England at that time. And there were certain people who said that, no, we will not accept this kind of a system. And therefore, they decided to leave England. And they boarded a ship named Mayflower. And they came to this place. And this place, at that particular time, as I told you, was considered to be one of the British territories. It was a British colony, technically, though completely barren. So they came to this particular place and they settled there. So now, what was the purpose of establishment of a new system and the new government in a strange place, deserted place? Later on, people from various other countries from the Europe also started coming. So important, and they settled in different places. So one important thing, the basic layer which you have to understand, that these people never came to USA, which is now USA, America, for any monetary gain. They never came to any economic benefit because we will have land as much as we would like. They came to this place only for freedom, liberty, especially the freedom to worship in any manner they like, accept any God they like. And so the freedom and the liberty and the religious freedom is the core of that particular society. And now question was that what kind of a government they should have in order so that they may not face that thing which was repeated to them in England, the theocratic dictatorship. And then they thought that we will not accept that system of government which was there in England. So the only perhaps the constitution in the world where they made doctrine of separation of power as the fundamental creed of that particular constitution society, because they thought that this is the only method by which you can run a government and enjoy your liberty and freedom, especially the religious freedom. There is perhaps no other country in the world. And therefore, there is in American Constitution, a vesting clause. Besides religious freedom as a fundamental right, there is a vesting clause which says all judicial powers are vested in the Supreme Court of the United States. All executive power are vested in the American president. And all legislative power are vested in the Congress of where the representative of the people sit. And the separation will be in its classical sense, meaning thereby that executive will never be a member of the legislature. Two completely separate things. For example, in India, our system is such where separation is no matter. We have a separation of power, though not specifically mentioned in the Indian Constitution, but there is a division of power. And the Supreme Court has said that doctrine of separation of power is the fundamental feature of the Indian Constitution by implication. But there, institutions are separate, the personnel are separate, the members are separate, and no institution can interfere into the functioning of the other institution. But as I told you that these fundamental deepest layers, according to the change in circumstances, can be changed. In fact, in that particular country, the judiciary was never given power of judicial review to declare the law passed by the parliament as constitutional or the action taken by the president as unconstitutional. And this is the most enigmatic development of the American constitutional history, that how American Supreme Court today got the power of judicial review. They can declare any law passed by the Congress unconstitutional. They can declare any action of the president as unconstitutional. From where they got the power. So they say they did not get this power from the Constitution as such, but they simply grabbed this power because they said two things. That one, when all judicial powers are vested in us, the judicial power means the interpretation of the Constitution, interpretation of the law, and interpretation of the executive actions. And so in 1803, when Marshall was the Chief Justice of the American Supreme Court, he decided a case, Marbury versus Madison, very important. And from that particular case, the court said that no, we have the power to determine the constitutionality of law and the constitutionality of the executive action. So deepest layers sometimes change also because of the changed circumstances. And the fourth deepest layer of the American Constitution, free enterprise. Free enterprise. Freedom of contract. Because they knew that development of the society cannot take place unless there is a freedom of contract. Because development societies are always been from status to contract. And so therefore, free enterprise. So these are the, I will say, though there are the others also, but these are the deepest layer of the American Constitution. And from these deepest layer, when we study various constitutions in comparative constitutional law, we try to develop certain universal deepest layers. So every constitution of the world must follow those deepest layers. And we try to develop a universal constitution and constitutional values. If we have an idea about the British system, though it is unwritten constitution, but I will say that it is not formally adopted constitution, no matter. There are certain laws which deal with the fundamentals of the government. But even then, they don't show us as we can show a copy of the constitution that this is the constitution of Britain, but they have some values. So the fundamental value of their system is majoritarian democracy. Majoritarian democracy. The parliament, representatives of the people, they represent the people, and they say that in any democracy, the people are sovereign. And therefore, the elected representative, the parliament in the British Constitution is supreme. So from there, we can learn that in a democracy, everybody should constantly try to bring the sovereignty back to the people and not to the various organs of the government. And second is the rule of law. The rule of law regulates the system in a manner that it saves the people from arbitrariness on the part of the government in the administration. Because they say that rule of law must govern all executive decision. The Dicey was considered to be the person who advocated the theory of rule of law as a fundamental feature of every constitution or any constitution. And therefore, he advocated that all law which govern people must come only from the parliament. And equality becomes the fundamental feature of every governance. And people must be saved from arbitrary action of the government. So rule of law, a definite principle of governance, which was acceptable to almost every society. And therefore, the deepest layer became a very importable, cherished commodity from the British Constitution. Now, hurriedly coming to Indian Constitution. What are our deepest layers? And what we call the constitutional values, because Constitution lays down not only about institutions, their powers and their functions, it also lays down the values of governance. And those values of governance determine the relationship of the people with the state. So what are the fundamental value which you call the constitutional culture? And perhaps you know now it is firmly established that violation of the constitutional culture is a ground for the Supreme Court to declare any law or any administrative action is unconstitutional. So first is, perhaps to my mind, democracy. Election by the people, the government is elected, government remains in power in India for a period of 5 years. But if the government loses the faith of the people in the parliament, that the important thing is the government has to resign. Perhaps you know that controversy which was there in the beginning when the constitution was being made. And the controversy was that should we have a parliamentary system of government or a presidential system of government like America? because presidential system gives the executive some kind of a permanency for a certain period of time so that they can undertake the management of the country very well. And so everybody said to Nehru that it is a good time. The country has never lived in democracy, never. And therefore, in order to give certain permanency to the administration for a certain period of time, we shall go for presidential form of government. And you will become the president. Nehru said, no. I want to bring real democracy to this particular country, because he said that our basic development is authoritarian. Our family structures are authoritarians. Our societal structures are authoritarian, because the system which was there was a feudalistic system. Structured inequalities have become the part of our system or culture. So he said, no, if I will not bring democracy in its full form to this particular country, nobody will ever be able to introduce full democracy in this country. So therefore he said that I will go for parliamentary system and not the presidential system, because presidential system has some kind of a germ of dictatorship in it. And that if we see the American history, we find that many cases the government has been locked down because the president programs and policies are not accepted by the parliament. So we went for a democracy more of a British type than of an American type. And then another very fundamental deep layer of our constitution is secularism. Secularism stands for religious freedom and inclusive society. Religious freedom and inclusive society. Meaning thereby that everybody must free to follow its own religion, his faith. He has the freedom to worship the God in which he believes. If he does not believe in any God, he is absolutely free to do that. So there will be no state religion. This is the fundamental layer of the secularism, no state religion. In America, perhaps you know that they had a very bad experience of back in England, where there was theocratic dictatorship. And they were very much scared with the theocratic dictatorship. And so therefore, in that particular society, they made this deepest layer of the society that state will not promote any religion, and not only that, state will not behave in any manner or undertake any activity that can show to the people that state prefers a particular religion. Not only that, you cannot establish a religion, you cannot act in any manner that shows that you prefer a particular religion, because that perhaps may hamper the faith of the people in the polarized society. So therefore, secularism becomes the basic feature of our culture, constitutional culture. Though this term was not there in the beginning because of various controversies in the Constitution added by 42nd Amendment later on, but it is said that they did not make any change because there was always, under Article 25 and 26, there was always a religious freedom which was available to the people. So secularism is the fundamental layer of our Constitution. And this talks of inclusive society, which is not polarized society. And perhaps the third basic layer of the Indian Constitution is social justice, a highly structured society when India became independent, a highly unequal society, a society which was feudalistic in character, highly divided economically and socially. And so therefore, everyone wanted that this problem should be solved first. And so they talked of social justice, meaning thereby that all our administration, all our programs and policy must be to bring the disempowered empowerment. Who are disempowered, they should be empowered, the basic feature of our Indian Constitution. And then perhaps closely allied to this is equality. Perhaps this social justice was always also not there in the Constitution, but it was added later on by 42nd Amendment. But it did not make any difference because there was a lot of things about social justice in the directive principles of the state policy and under Article 17, which abolished untouchability and the caste system in India. Basic layer. And the basic layer is equality. Equality, not the formal equality, but equality means differentiated equality, because that we learn from the American deepest layer. There the President Roosevelt said that opening the gate and allowing everyone to pass through it is not equality. Opening the gate and allowing everyone to pass through it is not equality. Unless all the people have the equal capacity to stand up and walk through the gate. Unless all the people have. So it means that equality is not formal equality, equality in capacity. Equality of opportunity is not sufficient. Equality of capacities. And equalities in result. What is the ultimate result? And that kind of a interpretation we accept in our country also, that equality does not mean uniformity. It means equality in capacities and equality in the result. And then perhaps the other fundamental feature which you can call the constitution, the constitutional basic layers are the freedoms, fundamental right, and the most important is liberty, and also the dignity of the individual. Because in our structured inequal society, which was based on caste system, which was a real problem for India to solve, and still now, even today, the problem could not be solved, is the dignity. So everybody should have the equal dignity. So this untouchability and this caste hierarchies should be abolished. And then another thing which is there is the fraternity. What is fraternity? Fraternity simply means, as our constitutional culture, a harmonious and well integrated society. Harmonious, well integrated society, meaning thereby a society which is not divided too much. And fraternity, on what ground you can integrate society? On what you can integrate society? So you cannot in India, as we see in other countries, integrate society by any force. You have to integrate society on the basis of certain values. When we all believe in certain common values, so naturally there will be a bond between the people. So fraternity means the brotherhood that comes into the society not for any other reason except for the values of the Constitution. If everybody believes in those particular values and considers those values as article of faith, then there will be an integration in the society. I always say that in a society, if there is no fraternity, then what will happen? That it will be very difficult for a person to exercise his fundamental right without any police alone, because other person are not sharing that value for you. For example, if a lady wants to go for a night show, she cannot go alone. No matter how empowered she may be an IAS officer, cannot go alone. Why? Because all the people of the society do not share the same values which that lady has. So unless everybody shares that value, that unity that comes on the basis of the value, and not melting the cultures of everybody and developing a new culture. The state has no right to melt the culture of the people and integrate them into one. The state has to do something by which everybody believes in the common values, and that common values they bring integration to that particular society. And then unity, and which means that no state can secede, which means absence of polarization in the society. So, in my opinion, these are the fundamental layers of the Indian society, and they become the culture. So, Supreme Court has very clearly said that if we do not follow this culture in our executive actions and legislation, then we shall have the power to declare that particular law as unconstitutional. Now, lastly, and perhaps, what is the fundamental, on what fundamentals these values have been constructed? So many people say that, look here, Indian Constitution, the wrong thing is that you have constructed the Constitution in a value which are Western values. So in my opinion, all these values are not Western values. These are not, no matter they say that these are the value of Renaissance, and certainly they are, but actually when we are constructing our constitution, we are not having in our mind those particular values. We are also having our own values. For example, I may refer the most ancient text is Rig Veda, which was written in about 1500 BC, which controls the conclusions of all the other Vedas. If we read that document, which contains the whole wisdom of Indian culture, even today, that clearly lays down that our whole constitutional values are based on Rig Veda. We have not drawn from any outside source. They were already there in our source. For example, Rig Veda recognizes the human rights of the people. The concept is not Western human right. It is our own. For example, Rig Veda talks of clearly about 3 human rights: the right to body, right to life, and right to a dwelling place, meaning by that every person's house is his own castle. So where you can find the best expression of human rights and its spirit, then you find in the Rig Veda. Then all fundamental principles of Rig Veda, they are the basis of our constitutional structurization and constitutional culture. For example, it says all human beings are equal in respect and human dignity. They find expression into our constitution about equality, about human dignity, about everything. Then another principle, fundamental principles of Rig Veda is that one person's rights is another person's duty. Meaning there were right and duties are correlated. This is not a Western concept. This is a concept which is clearly given in Rig Veda. Then perhaps 4, everyone has a right to choose his own religion, his own faith, is the fundamental principle of Rig Veda. And that clearly demonstrates in the basic layer of our Indian constitution when we seek the religious freedom. Then Rig Veda says, another fundamental principles of Rig Veda is that no human being should be under subjugation of another human person. Freedom, liberty, where you can find more expression about the human right of life and liberty. Then you find in Rig Veda when it says that no human being should be in subjugation of another human. Then another fundamental principle of Rig Veda is that law is the king of kings. Law is the king of kings. And another is that no matter how so high you may be, but law is always above you. Where you can find such a better expression for supremacy of law and equality. Where you can find better expression than this in the concept of rule of law or the separation of power. Then another fundamental principles of Rig Veda is that let knowledge come from every corner. And this fundamental principle is the basis of our freedom of speech and expression, universal thought and action. Another fundamental principle is treat world as one family. Everybody is the part of the same human family. Where you can find such a better expression of an inclusive society, an equal society, and just and fair society. So my purpose is to say that the values of our constitution are not basically based on foreign values, no matter they are the same. But look at the 1500 years when this document was written, Rig Veda. all the values which are there in our constitution you can find in this particular sacred text. And therefore, we seek no other source to validate those our values. We seek our own source to validate our values. Unfortunately, that today we have forgotten those particular texts which are there. And now, if I have some time, I will talk about that how the comparative constitution has benefited us, or we can take it at a later stage. And therefore, now perhaps very little time is left. So, open to discussion and question and answer if you have any.
Okay, all the participants, uh, the session is now open as suggested by Sir for you to ask any questions. So if there are any questions, you can raise your hands. I'll give over the virtual dais to you. You can write your questions in the chat box, or you can directly unmute yourself and ask the question to the resource person. Are there any questions? Okay, so I hope there would be some other questions, but I have a question, sir. I have a question
Yeah.
based on your discussion on what are the deep fundamentals of different constitutions. Now, we have often heard about constitutional morality. Okay.
Mm-hmm.
Now, you have talked about constitutional culture. You have talked about deeper values of the Constitution. So, my question is there a distinction to be made between these deeper values and constitutional morality, or are they same, or are they interrelated?
Interchangeable.
Okay,
Yeah.
that's one. Yeah, interchangeable.
So we
And
use so
a
many
related
expressions.
question,
Mm-hmm. So
and
many
yeah,
expressions.
go ahead.
We use so many expressions for this. And now, after the recent decisions of the Supreme Court in LGBT case in 377 and other cases, this term has become very common. So if you read those particular judgments, that you will find various expressions, even the judgments use. And they, in my opinion, they perhaps use the word fundamental values of the Constitution, the fundamental features of the constitutions, the morality of the Constitution. Morality means that you bring certain moral principles into the hard law that you pass. And those particular principles you find in the values of our constitutions, which are enshrined generally in the preamble of every constitution. So these all words, the basic feature, the basic values, the deepest layer, the culture, morality, perhaps they converge on the same point and they relate to the same thing, which we call the deepest layer of our Indian Constitution. And do you know that how this comparative constitutional law has benefited the Indian Constitution and the Indian people? One very important aspect is that because of understanding the deepest layer of other constitutions, the Supreme Court could bring in the idea of due process into Article 21. Had there be no comparative constitutional process, they could not have done. And Indian people have suffered, should have suffered like anything, so far as their right to personal liberty is concerned. And the second most important thing, and that idea was taken from American Constitution, because deepest layer of the American Constitution is the due process, which is given under Article 14, Amendment 14 of that particular Constitution. The second most, which I say, is the basic feature theory that we developed after understanding the deepest layer of the German Constitution.
Okay.
And perhaps these are the two additions which were made to the Constitution, which we can so call the judicial additions or judicial informal amendment to the Constitution. They have done a very lasting benefit to the Indian system of governance, because it has saved people from the wrongful arrests, torture, detentions, and everything in all conditions of life. And they say that the procedure is not which is laid down by the legislature. The whatever legislature has laid down, the procedure for depriving a person of his liberty must also be fair, reasonable, and just. And the basic feature theory has saved the Constitution itself from the whims and approaches of the various political parties. Because had this been not there, our Constitution would have become a playthings in the hands of the various political parties. And so these two additions, which are the product of comparative constitutional law, perhaps is the most fundamental benefit which this comparative constitution law, which we call the universalist approach, we go on shopping and get the best for ourselves. Perhaps that is the best benefit that can be done to the Indian society.
Okay. Okay. So, sir, one more point I just wanted to ask. Dr. Sandhya, do you have a question?
Yes, actually, I wanted to ask a question where, sir,
Yeah, go ahead. Go ahead. Go ahead.
First, you identify yourself. Doctor?
Yeah.
Dr. Sandhya Kumari, sir, I'm teaching as Associate Professor
Acha.
of Law at
In-
Galgotia University.
Acha. Galgotia University, Delhi. That's
Yes.
good. Good to see you.
Thank you, sir. Same here, sir. Sir, I was referring to your statement where you refer to Rigveda, and you said that no human being should be under any other human being's subjugation. But when we take employment, especially in employment, I'm not going to the gender aspect of it because then it will be very prolonged. So when we talk about employment, so has the Rigveda referred to this aspect of it as well, and how much subjugation can be done through employment?
So when we are talking of subjugations, we are talking of possessing the body and the spirit of that particular person by another person. But so far as the, because you know that another fundamental aspect of the yoga is, Rig Veda is yoga. And yoga is nothing but the discipline of mind and discipline of body. So if one is regulating the other person and that person has given his consent for it, then in that particular case, you cannot call it a
Not
subjugation.
on our end.
So, judiciary,
Yeah.
sorry, the in employment conditions,
No worries. No
who
worries.
have voluntarily
You can join
accepted
next.
that kind of a discipline in which you have to be work under a particular system. So perhaps it will not come under the definition of the term subjugation. Subjugation is absolutely different thing. And if your liberty has been deprived according to the law, and that law is reasonable, fair, and just, then it will not be considered to be a subjugation, or it will not be considered to be slavery. But otherwise, subjugation, as you see in case of feudalistic order of lower caste by the higher caste. When you see in subjugation in this sense, when you see the bonded laborers. So that kind of a situation where you are being subjugated and controlled by the other, but it will, for your benefit, if it is with your consent, then to that particular extent, everybody has to surrender some of his liberty in order to live in an organized society. So that kind of a surrender of some freedom is the part of the freedom of equality and freedom and equality. So reason, but it must be very reasonable, fair and just. If it is not reasonable, fair and just, then it will become subjugation.
Thank you for your answer, sir.
Okay.
Any other?
Okay. Yeah, sir.
So
Hitesh, you want to ask a question?
Yeah, good afternoon, sir. After listening to your
you have
thoughtful
to
lecture today,
first you have to
Introduce yourself,
identify
Hitesh.
yourself.
Please introduce yourself.
sorry, sir. This is Hitesh Manglani, Assistant Professor of Law at ICSSR Law School, Jaipur, sir.
Acha, Jaipur, you are very near to our place. Huh?
Yeah, exactly, sir.
Yeah.
Sir,
Good
my
to see you.
question is, yeah,
Hmm.
thank you, sir. Same here, sir. Same here. I mean, sir, after listening to your thoughtful lecture, one thing that comes to my mind is as to while analyzing the success of Indian Constitution, specifically, very particularly in Indian society, do you think that the success of the Constitution must be analyzed on the basis of its ability to touch or satisfy the moral conscience of the population?
True, but the fundamental thing about any governance is that it must take care of the holistic development of one's personality, his physical needs, emotional needs, his cultural needs. So, not only one aspect, but they must take care of in a holistic manner of the individual and the society as a whole. So that is why the Constitution has laid down these values which are applicable to the individual also, and which are there for the uh, state to take care of. For example, the uh, caste system in India. So Constitution has abolished caste system, untouchability. So it is taking your personal moral values into consideration, that your moral values, which you, if you believe in untouchability, they are not valid after the Constitution has come into existence, and they have taken the whole system of society into consideration. When the society becomes unequal, it is a very unstructured society. So they take care of the individual also, and side by side the society as a whole also. So not only your personal preferences of morality, if they conflict with the fundamental layers of the Indian society, they are not valid. But where there is no conflict, they are valid. For example, the case of the same sex, the Supreme Court has given the decision. So in this value, you have to make a harmonious relationship or harmonious balance between the individual and the society, which is a very difficult thing to do. but every society or tries to balance it in their own way through their laws, through judicial interpretation, and through the executive actions. So we are talking of here, the Constitution talks of societal value, which should be based on the values which are valued by the society and agreed to by the people in the form of the Constitution. So now we can.
Thank you so much, sir.
So we can end now.
Yes, sir, with your permission, if you so permit. I guess there are no more questions. So yes, sir, with
Because
your due permission,
another thing I may tell you that asking question, because now people say that everybody must ask questions to the governments. Not asking question is a part of our culture. A person who does not ask question, does not challenge the other person, is considered to be the very good human being. For example, from the very beginning in our homes, the child should not ask question from the elder. They must sit quiet, not open mouth when the elders are speaking. So this is the part of our culture, not to challenge anybody unless our interests are in a way directly affected by it. That is why, but the fundamental principles of democracy is everywhere is that everybody should ask questions and everybody should learn to challenge. Otherwise, very easy to lose your liberty and freedom in a particular society. So that we can learn from other societies also. And somebody says that if there is a lecture by a university professor and he is a British professor, and after the lecture there are no questions, he is very happy that perhaps whatever he has said, everybody has understood, and there is no confusion in the mind of anybody. But if a person is giving lecture and he is an American, so he is very unhappy that how what I have said, nobody has any reaction to it, and I have not been able to create some kind of a confusion in the mind of the people, and because they are very unhappy if they are putting the mind to rest of another person. The purpose of the lecture is to further the questions and inquiries and inquisitiveness of the person. So he's very unhappy. Being an Indian person, the mixed reaction. So it is always there when we teach in the classes. Thanks, everybody. And it was a
thank you
pleasure.
so much, sir.
Okay.
Thank you so much, sir. Thank you, sir.
So we will meet again then. Okay.
Yes, sir. Yes.